hand over to our first speaker, but just before we start, please remember to keep your video turned off except for the presenter, and please could you remain on mute. If you do have a question, you have the chat facility available, or you'll be able to raise your hand, and we will take these questions at the end of each presentation. Without further ado, let me hand over to our first speaker, Talita Laubscher from Bowman's Law, addressing workplace vaccine policy. Is it legal to make it compulsory to take the vaccine? Talita is a partner at Bowman's Law and specializes in all aspects of employment law, including the drafting of employment contracts, policies, and procedures. Talita will provide insights into mandatory vaccine workplace policies, including the legal and ethical issues. She will also cover specific considerations for medtech field teams who may have to comply with mandatory vaccine policies issued by healthcare providers. Welcome, Talita, to the SAMED meeting, and I'll hand over to you. Thank you.
Thank you very much, Avanti, and thank you very much for inviting me. It is such a privilege for me to be here today. I would like to share my screen if it is possible.
Please go ahead, Talita.
I think it's this one. Sorry, technology is not my forte. Let's see. Can you see it?
Not yet, Talita. I can also share from my side if that is easier.
Yeah. I will appreciate that.
No problem.
Thanks, Clara. Thank you. Excellent. Thank you very much. On my side, there is a little bit of a double screen. I assume that is not the same with you guys.
No, you're in presentation mode. Thanks, Talita.
Okay, fantastic. Thank you.
Okay, you've gone off now. There we go, back again. Thank you.
Thank you. So this is the one area of this COVID pandemic that is unbelievably intricate because of the various rights and obligations that are provided for in legislation and that need to be balanced. And such a balancing of rights is always a difficult exercise, but thankfully the National Health Act and the Occupational Health Act give us parameters within which we can navigate the path through these interesting pieces of legislation. So if we can go to the first slide, and I think we can actually skip over that. We all know that the aim of vaccinations is to create herd immunity, and we are targeting 67 to 70% of the South African population by the end of the year. As Avanti mentioned, there's a phased rollout, and healthcare workers would then be in the first line. So in the employment context, the most familiar section dealing with anything to do with medical testing is Section 7 of the Employment Equity Act. And that section regulates the circumstances in which an employer can require an employee to be tested. And it says things like where it is necessary for the fair provision of benefits or employment conditions require it, things like that. So it already focuses the mind a bit. But medical testing is not medical treatment. And when we are talking about a vaccine, we are not talking about people going for a COVID test or for a drug test or alcohol test. We are talking about medical treatment, something that is put into your body for a specific purpose. So although this section 7 might give us interesting points to refer back to, it is not the section or the legislation that will govern employers on determining whether employees can get treatment. So then we need to ask ourselves, what does the Grundnorm of our legislation say about this? And that is the Constitution. So let's start at the very beginning, as Maria von Trapp would say. Let's start at the Constitution. The Constitution says we have the right to freedom of conscious religion, thought, belief, and opinion. The Constitution also says that we have the right to bodily integrity. And those are two very important rights in our Constitution. But as any right, they are not absolute. And in particular circumstances, they may be limited. So let's look at the National Health Act. That act gives effect to the right to bodily integrity. And importantly, in Section 8, it gives the user, the patient, the individual, the right to participate in any decision affecting her or his personal health and treatment. And Section 7 says a healthcare service, like a vaccine now, may only be provided with the user's consent. That consent is defined in the Act, and it consists of 3 elements. It must be informed, it must be specific, and it must be voluntarily given. So we then look at Section 6 to see what must you be informed of, and that is the health users. Have I lost you?
We're just back to your presentation, but not on presentation mode.
Oh, are you? Oh, that's
okay. We're back.
Thank you. Okay, thank you. You must be informed of your health status, the range of treatment options that are available, the benefits, risks, and consequences associated with each option, and the right to refuse the treatment, as well as the consequences of such refusal. And that emphasizes the voluntary nature of these vaccines. Section 7 also says it needs to be consent to the provision of a specific health service. So it needs to be specific. A consent upfront in an employment contract that the employee will undergo whatever treatment as the employer might require from time to time is not meeting that requirement, that it needs to be specific. The beauty of law, and especially employment law, is that there is always a but. But there are exceptions. And these exceptions are set out in Section 7 of the National Health Act. And it says that the provision of a health service may be given without consent where that is authorized by a law or by a court order. Things like a blood transfusion for a child whose parents have objected typically fall within that exception. And importantly, Section 7(1)(d) says you can administer treatment without consent if there is a serious risk to public health if you didn't do it. So in our current circumstances, we do not have legislation that forces the vaccine and makes it compulsory. So under the National Health Act, what you would need to look at is whether not doing so would result in a serious risk to public health. In the employment context, again, specifically, the Occupational Health and Safety Act places an obligation on employers to provide and maintain a safe working environment, not only for its employees, but also for other people that come in contact with that employer and its business. Interestingly, those first subsections of Section 8 says, as far as reasonably practicable. Again, therefore, it is not an absolute that we are talking about. It is something that needs to be checked. Is it practicable? Is it possible? Can it be done without unnecessarily infringing on someone's rights? Also, the general safety regulations say for safety purposes, the employer may restrict access to the workplace. And it is precisely on this basis that employers can say, if you are having COVID symptoms or have been in contact with someone who have tested positive, or if you yourself have no symptoms but you tested positive, stay away. Don't come to the office. It is on this basis that the employer may restrict access. Now, will the same apply to employees who are perfectly healthy, but they have decided not to take the vaccine? That is what we need to answer. Now, these principles are not new. It is the right to bodily integrity is something that employers deal with very often when it deals with incapacity, ill health dismissals. And you will all be aware that in those circumstances, the employer can say to the employee, we see that you are suffering from an illness and you are taking excessive sick leave, and we need now to take steps in order to address the situation, because ultimately the employer does have the right to dismiss for ill health. And as part of that process, it can require the employee, it can ask the employee to undergo a medical examination, but it cannot force the employee to do so. So it can say to the employee, listen, we want to make a decision based on all the available facts. And for that reason, we want you to be examined by this doctor that we have identified. And we want you to share the doctor's report with us. That needs to happen with that employee's consent. We cannot force the employee to do so. Also, the employee cannot put a gun to the employer's head, as it were, by simply refusing to do that, because the employer is then entitled to make a decision based on the information that it has available, the records of excessive sick leave, the impact that the absence is having on the team, the employee's poor performance because they are just simply too ill to work. It can then still proceed with that process. But what it cannot do is force the employee to go to the medical examination. So again, that gives us a little bit of context as to how we should go about balancing these rights. So on the one hand, we have the right to bodily integrity, the right to participate in decisions concerning your treatment, the right to freedom of religion and belief. But remember, they can all be limited. The right to bodily integrity can be limited if not having the vaccine amounts to a serious risk to public health. And the right of freedom of religion can be limited if accommodating that religious belief may result in undue hardship for the employer. Now, on the other hand, we have the employer's right to conduct its business and its obligation to ensure, as far as reasonably practicable, a safe working environment. And the factors that you consider in that regard are things like the severity and scope of the hazard, what we know about the hazards and how they may be removed or mitigated. Importantly, the availability and suitability of other means to mitigate the hazards and the cost of doing that. And that very interestingly linked back to that exception on the serious risk to public health. These two acts need to talk together, and we need to read them together in getting to an answer. So if we now look at these factors, we said we must look at the severity and the scope of the hazards, and that depends to a large degree on the nature of the workplace and the type of work. So healthcare workers, they are at the front line, they are dealing with ill patients, and there is the duty on hospitals to ensure a safe environment, not only for employees, but also for patients. And then we have circumstances where there's a finance manager somewhere in their own office, going up the lift and down the lift, no real contact with co-employees or with members of the public. What we know about the hazards is COVID-19 is contagious and it is serious. Just excuse me for a minute. We know, and we do need to listen to the science, that transmission is mitigated by the vaccine. And I am not a medical expert, but what I understand is that it has an effect on the viral load. So if you are vaccinated and you get the illness, you are not getting as ill as you might have had. And that also helps that you are not as contagious towards other people. I don't know all of that, but I understand that is part of it. You can educate me on that, please. What we also know is that it is not 100% effective. So it might be necessary to still use other health and safety measures in circumstances where there is this risk to public health. The herd immunity, as we saw at the beginning, may be achieved if 67 to 70% of people are vaccinated, not 100%. So we may achieve our goal even if not everybody takes the vaccine. The availability of means to remove the hazards. The vaccine isn't available to everybody immediately, so we will necessarily have to use the now normal methods of hand sanitizing, mask wearing, adequate space. But again, these measures may not be practicable in all circumstances. For example, call centers, food manufacturing, hospitals, operating theaters, airlines. And then the other question that you need to ask is who will bear the cost? So if we look at the mandatory exclusion of persons not vaccinated, the employer can say, all right, those who want to work from the office must be vaccinated. If not, continue to work from home. But if you come into the office, you need to tell us, this is the, I had the vaccine. And there will be no adverse consequences to the employee. Employment is not going to be terminated. The employee is not going to be prejudiced in terms of remuneration or bonuses or leave or anything like that. So the employee still has the choice to get the vaccine or not. On the other hand, the employer could say you must come to work because this is where you work. You work in the operating theatre at whatever hospital, and you must get the vaccine. And if not, then we are going to dismiss you. Now, this is not strictly voluntary, and that will only be permissible if not getting the vaccine results in this serious risk to public health. So labor-intensive workplaces like mines, factories, call centers, they might potentially fall into that category, or workplaces where the employees are serving or impacting members of the public, like retail, food manufacturing, transport, health workers. So if it is employees who are not in contact with the public and very little contact with fellow employees, I think it is going to be difficult to justify requiring the vaccine. If it is in workplaces where there are lots of people, or it is these workplaces that service the public, then I think we are moving towards potentially being able to require the vaccine. Now, as we said, religious or conscientious objectors will need to be looked at carefully. And as we said, that right can only be limited if not accommodating the religious belief results in undue hardship for the employer. We have cases from the Labour Court and Labour Appeal Court that deal with this. There was a recent decision from the Labour Appeal Court where the employee refused to participate in a stock take that was held once a month on a Friday evening, and that was based on her religious beliefs because she's a Seventh-day Adventist. Over the period that she objected, the stock takes took place in the normal course. There was no adverse effect on the employer. The only issue that the employer really had was that this is not fair because other people must now come on a Friday and she is not coming. Secondly, she is not getting the exposure to this area of the business, which is actually a requirement for people to progress through the organization. And the court said, actually, these are not factors that tell me it is undue hardship on you, and you need to accommodate her religious beliefs. Dismissal is a last resort. So we cannot just simply dismiss employees without looking for alternatives. And this also is not a new requirement in labour law. So if now 70% of people in the workplace get the vaccine, is it really going to cause us undue hardship to accommodate those who have conscientious objections? It might be different if only 20% get the vaccine in those specific instances where some form of a mandatory requirement may be applicable. But if 70, 80, 90% gets the vaccine, is that still a question of undue hardship, not to accommodate the one that actually objected? Also, I need to add that the religious objections are only permissible where they form part of the inherent tenets of that belief. So there is also a burden of proof on the employee to say, this is my belief and what I believe, and this is the basis for it. It cannot just be a random idea on the part of the employee. There needs to be a basis for that. And if there isn't a basis, you can then require the employee to comply with what your policy is. Other issues to keep in mind is that we have the Protection of Personal Information Act. Health information is special personal information, and one needs to comply with the provisions of the Protection of Personal Information Act when you are processing the information. This means the employee must either consent to the processing of their vaccination status, or the processing must be required in order for the employer to comply with its legal obligations, for example, those under the Occupational Health and Safety Act, to ensure a safe working environment. If the employer wants to rely on consent, again, the consent must be informed, voluntarily given, and specific. Another question that comes up is, what if the employee demands a vaccinated workplace? So the employee is saying, I am not coming to work or to the office premises or the hospital or wherever if everyone is not vaccinated. Is that a lawful demand? One would need to consider that carefully, and again, the same principles will need to be looked at. If it is circumstances where not being vaccinated really poses a serious risk to public health. And, you know, lots of the employees are refusing and are not getting it, so that we cannot achieve our purpose of herd immunity, then potentially there might be something there. Otherwise, I'm not convinced that that is a lawful demand by one employee to demand that it's his or her colleague need to go medical treatment without voluntarily giving consent to that. So this is a mouthful. I'm happy to take questions.
Are there any?
I have a question. It's Dave Roberts here from Johnson & Johnson. I don't know if you're going to have the answer for this, but it's an interesting dynamic of some comments are made that the hospitals will insist on all sales personnel to be vaccinated before they go into the hospital environment. Everything that you've said sounds like they will be permitted to make that demand. Am I right?
Yeah, again, Dave, there are all these different rights and interests that come into play. There is the patients in the hospital who may not have the vaccine and who may be compromised if they get COVID-19. The hospital's duty to ensure patient safety is another important consideration. And it is very similar to the situation of airlines, where they are saying, well, everyone who fly on our planes need to show us that they had the vaccine. And therefore, everyone who work on the plane, the air stewardess and the pilot and the co-pilot and the captain and everyone else, they need to show us that they had the vaccine, because they cannot apply something to people who fly and not to their own staff. So it might have a knock-on effect. Now, when you are dealing with reps, I understand that, and again, you know, I know this from second-hand knowledge, but I understand that in some instances it's actually very important for that rep to be in theatre and to assist with the procedure. And if that rep hadn't complied with that requirement of the hospital to be vaccinated, then the rep cannot be there. And the obligation to accommodate that rep would fall on the company. And they may need to send another rep to assist with that operation. So it's not, you know, for the hospital to then deal with that situation, but the hospital needs to make sure that it is a genuine requirement. And without knowing too much about how these things work in the hospitals and whether there are potentially other ways in which to ensure safety, like those full-blown suits that you might wear, it might be that the company will need to ensure that, you know, this is done so that there can be compliance with that requirement. But again, you know, if there are less invasive ways to achieve the same purpose, then I think the right to bodily integrity might trump that, as I say, you know, through wearing all those interesting suits that that we see on the news feeds.
Thank you very much.
Thanks, Talita. I see that the other two questions that are in the chat are quite similar. They are about you know, third-party staff being permitted into theatres, as well as those that are doing training in hospitals and labs also being mandated to take the vaccines. Are there any other questions? Perhaps one for myself. So if the employers are mandating the vaccine, if they break that into a workplace policy, what should they be putting into that in terms of the legislative side of things? So what should they be putting into their policy?
I think they need to sketch the context very carefully and very clearly, so that they can, if challenged, prove that they are doing this because of their obligation under the under the Occupational Health and Safety Act to ensure a safe working environment, and that not requiring this vaccine is posing a serious risk to public health, and then explain why they say that. Then they will need to make provision for religious objections and say, that those will be considered on a case-by-case basis, and that it will be determined on a case-by-case basis whether accommodating that religious belief may or may not result in undue harm for the employer. Also, the vaccine may not actually be available for a large portion of the population before the end of the year. So one also needs to take that into consideration when you are writing these policies. My gut feel is that it might be better to do education and encouragement to obtain the vaccine rather than to force people to get it and to make it mandatory. And one way of doing that might be to say the company thinks that there is value in this vaccine, and these are the reasons, this is the science behind it, and educate employees about that, and then say, when the vaccine becomes available to the general public, if you get the vaccine by March next year or June next year, the company will pay for it. But that is more of an encouragement and an education perspective on the matter rather than the stick perspective.
Thanks, Talita. Are there any other further questions?
Hi, Talita. It's Mornay Els here from Edwards Life Sciences. I just wanted to clarify on the element of public risk. So if you look at the option that, or the step that an employer can take to enforce vaccination, if you look at the medical industry, ultimately, if you look at where these individuals are circulating in hospitals and theatre and transferring from a green zone to a red zone potentially, that should, in my view, justify as a high public risk. Then in communicating to an employee to enforce the vaccination, what's the steps that an employer can take to justify that public risk?
I completely agree. So the employer would say, this is the context of our workplace. This is how we, operate and how we work. We come into contact with patients who are already compromised, and there is a high risk to public health if we are not using this mechanism that is now available, because, talk about the viral load that goes down if you get the vaccine, the less likelihood, although I know it's probably not completely excluded, that person might still carry the virus and, have it transmitted, but at least there is evidence that there is a reduced risk of transmission, and set that all out carefully, not in difficult language, and explain to employees this is why we require it. And if you have questions, talk to so-and-so, and then take it on a case-by-case basis, when employees do object.
Okay, thank you very much.
Would anyone else like to ask a question? No one else. Okay, then I would like to say thank you, Talita, for your time. Thank you for the presentation. I think it was very informative, and we appreciate the insights that it has afforded our members.
Pleasure. Would you mind if I stay for the rest? I'm quite curious to hear the.
Welcome.
Thank you very much.
You're more than welcome. Yvonne, I just want to check that you are on the call. Yvonne?
Yes, I'm here. Hello, everyone. Can you hear me? Can you see me?
Hi, Yvonne. Yes, I can see and hear you clearly. Just so Yvonne will be our next speaker. Yvonne is joined Elsevier Klink and Associates in 2019, and her expertise is in the field of workplace injuries and disease compensation. Yvonne will provide us with some insights into the legislation, what the legislation says, and how to manage workplace-acquired COVID-19. She's going to also cover the definition of what workplace-acquired COVID-19 is, the responsibilities of both the employee and the employees, the employer and the employees, and the processes to follow as the employer or employee with workplace-acquired COVID-19. Yvonne, thank you very much for joining us today. You're welcome to share your screen from your side.
Okay, let me just do that. Okay, got the presentation open. I'll just share.
Yvonne, are you managing? We can see your screen.
Okay, I just want to open my presentation.
No problem.
For some other reason, I can't find it. Can you see it?
Yes, we can. If you can just take it into presentation mode. Thanks.
Okay. I just want to go to the beginning. Okay. Is it in presentation mode?
It looks like it, yes.
Okay. Okay, so thank you so much everyone for this opportunity, and thank you for the introduction. I will then be covering, today we'll look at the landscape in changing health and safety. This is the presentation for you guys to have a look at. Because the time slot is so short, I won't be speaking to each and every slide, but I'll just give explanations as we go along, and also to give time for questions. Everyone can still hear me?
Yes, we can. Thank you, Yvonne.
Okay. So about the legal frameworks and the understanding and the rights, we base everything on the Disaster Management Act, which I'm sure you guys have discussed, as well as the Occupational Health and Safety Act. The Occupational Health and Safety Act is the one that would play the most role in terms of workplace contracted COVID-19. What's important is to understand that as an employer, you need to have an Annexure E plan. This is where you have a plan in place where you have assessed the risk, and you've put in the preventative measures in the workplace to ensure that employees don't contract the virus, or any other clients or customers or representatives that you might be dealing with in your organization. So part of the Annexure E plan is that what it basically covers, it tells you what, as an employer, who you are required to report to should someone contract the virus, or if you have a certain number of employees who you need to report to, which we'll discuss. There's also tracking and tracing that needs to be done by the employer, and I'll also discuss that going forward. So the Disaster Management Act and the regulations, as well as the Occupational Health and Safety Act, then would require that in your Annexure E plan, there's certain things that need to be there. I've just listed them shortly because it's quite extensive. But when you do then proceed with commencement of business, you need to ensure that you have, it's clear that when your hours are, when you open, when you close, a timetable that sets out the phased in return of work. So meaning that if in the event there are employees that can work from home, it is encouraged that you then keep employees that can work from home to work from home, especially those who are identified as vulnerable employees. Those would be the people over the age of 60 and over, and all those who have who have comorbidities or live with people who have comorbidities at home. So you must take workplace steps to get COVID-19 ready. Your staff who can work from home must work from home, which I've already discussed. There must be sanitary and social distancing measures and facilities at the entrance and exit for the workplace, screening facilities, attendance record system, infrastructure, work areas, and canteen, bathroom, allocated places. What I also just wanted to mention here is that in your Annexure E plan, it's also important to then also have a designated area where in the event that someone contracts COVID, because you would have to, as an employer, then remove the person from the other employees and cordon them off into a specific area, but we'll discuss that as well. So we assist with Annexure E plans, and you'll see when we assist you with your Annexure E plans, we actually then put in all the protocol documents that would need to be in there for the screening, as well as for where personal details of everybody who comes in and out of your offices would then need to complete. So across all levels, and as long as the regs are in place, there's general measures which would be under regulation 5 and 13 aspects plus other 18. So this is what the duties of an employer would be. You would have to provide masks. Generally, the requirement is to provide cloth masks, and that's so that there's enough surgical masks for frontline workers. You need to then allocate your floor and space, make sure that there's the 1 meter space between persons who need to be sitting in a waiting area. You need to ensure that your queues are regulated and monitored, and also that there's social distancing, that there's sanitizers available within and around the workplace. And then there needs to be a designation of a COVID-19 compliance officer. This is the person who will monitor and implement your Annexure E plan. Where people can work from home, you minimize physical presence, you let people work from home, and then you can implement a work from home policy as an employer. It's advised that physical meetings are limited at all times if that is possible, and vulnerable employee measures must be taken into place. For example, vulnerable employees, as explained earlier, would be those people who could possibly work from home. Couriers and delivery needs to also be minimized and monitored in terms of the contact. And then it's important to note that failing to implement or report in terms of your Annexure E plan is a criminal offense under the Occupational Health and Safety Act, and that inspectors at the Department of Employment of Labour can conduct inspections to ensure that you have implemented the Annexure E plan. At this point, you would have to make this plan available to the inspector. Yeah. And then there's nothing about psychological well-being, but we recommend that this is included in your Annexure E plan. I did see on a guidance note of workplace in the event of identification of COVID-19 in May 2020 there is some mention of counseling that would need to be provided by the employer should an employee contract the virus at the workplace, which we'll also discuss further in our slide set. So the Occupational Health and Safety Act, what's important is section 8. Section 8 basically speaks to the Annexure E plan, that as an employer you have duties towards your employees by taking steps as may be reasonably practicable to eliminate or mitigate any hazard or potential hazard. This is your risk assessment that you'll have to do in and around your workplace to ensure that you eliminate or mitigate. You make arrangements for ensuring, as far as reasonably practical, that the safety and absence and risk to health in connection to the production, processing, use, handling, storage, transport of articles and substances, like we spoke about, the couriering, delivery services and things like that, and establishing what hazards to the health and safety of persons affected. So this would be everything that you would do that is outlined for you in your Annexure E plan. And you also have duties towards others. This is to ensure that persons other than those in your employment who may be directly affected by the activities are not thereby exposed to hazards to their health and safety. So in the regulations, they look at visitors, people who then would be visiting, whether that would be reps or possible family or just walk-in people that come to visit at the premises, and what needs to be taken care of in that event. So we always use the law of general application. Occupational health and safety is enshrined via the South African Constitution, and we also know that the limitation must be reasonable and justifiable in an open democratic society based on equality. So that is just for FYI. I also put in a side note on the impact of non-adherence to law on claims. And this is just a note to say, check with your insurance. It's just information as well. So I'll skip that. What I've done is that I've went to go and look at the definitions of close contact. And the reason for this is that when you're assessing whether or not an employee contracted the virus, either at the workplace or outside of the workplace, the definition of close contact is important. And this is also for you to be able to establish whether the risk is low or whether the risk is high. And the reason for this is that where you've established as an employer that it was a low risk in terms of contact, an employer can still continue to work, just provided that they are monitored and that they're provided with a surgical mask. And you would then, as an employer, have to monitor them. Where there's high risk, this is where we would talk about assessing the person's health condition, whether they need to be admitted, or you send them home, and then you would ensure isolation and quarantine. So close contact, this is a person having had face-to-face contact, 1 meter, or being in a closed space with a confirmed case for at least 15 minutes. This includes, amongst others, all persons living in the same household as a case and people working closely in the same environment as a case. Healthcare workers or other people providing direct care for case while not wearing recommended PPE. The definition also goes on to talk about close contact in an aeroplane, in a plane where you're sitting 2 seats apart, or where you are being served by the flight attendants and so on. But I just thought for this definition was enough to cover our session today. So I went to go and look at what is the definition of a workplace acquired COVID-19. I've looked everywhere. I couldn't find any definition. And I think the reason for this is that as a department, I think the Department of Employment and Labor haven't really defined this, because sometimes it's still difficult to ensure whether the person actually contracted the virus at the workplace or when they were on their way to the workplace, referring to people who might be using public transport, or whether they contracted the virus at home, because screening protocols might not reflect at the time that the person comes into the office. So I think that is why they didn't put a definition down, but I stand corrected. What I did was I went to go look at the consolidated directions on occupational health and safety measures in the workplace, which is dated, the latest version is the 28th of September last year. And the two definitions I could find was worker, and the worker is a person who works in the employer's workplace, and that includes an employee, independent contractor, a self-employed person or a volunteer. And then they also define workplace, and then they say the workplace is the premises or place where a person performs work. So in my mind, then it would be then that the definition for a workplace-acquired COVID-19 would be when the person presents their symptoms at the workplace at the time, and what it is that they need to do as an employer should that be the case. So the procedure for workplace-acquired COVID-19 is that according to these guidelines of version 5, May 2020, which I referred to in the previous slide, the employer is required to provide prompt counseling. You immediately provide this person with a surgical mask, and you relocate to a well-ventilated area, that needs to be secure, well-ventilated area. You have to have the person's clinical condition assessed. If the person doesn't need to be admitted, you can send the employer home, and then you need to ensure that the employee self-isolates at home or at a designated isolated facilitation, which could be identified by the employer. You need to ensure that the employee is also not discriminated against by testing positive. This would mean that there would have to be some form of education and training on other employees who could have been at the workplace when the person was identified to be COVID-19 positive, and also to assist the employee where there is a medical aid, where the employee has medical aid, inform the employee that that COVID-19 interventions are part of PMBs. We have seen there's a shortfall sometimes with the medical schemes in terms of providing COVID-19 as a PMB, but it just takes a little bit of a push and a tug, a letter that could be written to the scheme. There is mention in the guidelines that the employer can also assist the employee in this regard. So the employer also has a duty to report. You need to report then, should a person be identified as COVID-19 positive, you would then report the person's personal details of the infected employee to the NICD. You would initiate contact tracing of fellow employees. You would assist the Provincial Department of Health and the NICD to identify close contacts and facilitate quarantine and isolation of other employees should it have been a high risk, and there's a chance that there's other employees that could have been infected. And as usual, it's an incident, so it must be reported under COIDA, and the employer, because we know that there's been a delay with funding from COIDA, the provisions do state that the employer might have to then cover the medical costs where there's no medical aid until COIDA covers the costs for the employee, the medical costs. Once you've done the reporting, you would then have to reassess your Annexure E plan, because then it means that the plan that you had in place probably had some gaps, and then you need to reassess the plan to identify what those gaps were, what went wrong, or what measures wasn't in place for the person to have had contracted COVID. You would provide PPE where necessary and employees to access the PPE where necessary. You will relook your social distancing policies, training of your staff on the preventative measures again. Work areas need to be then cleaned and decontaminated. You must manage the return of work of the affected employees. And then what I wanted to add here is that if you fail to report, I think I've mentioned this, it's a criminal offense, and I've put the section there for you, which would be under Section 38. And also that in terms of Section 30 of the Occupational Health and Safety Act, an inspection can then be conducted, and this is where you then need to then avail your Annexure E plan. Okay, so we've put a list of tips to say that this is for where we deal with organizations where there are global policies. We advise that a global policy is not enough, and it must be localized and referred to local legal frameworks and protocols. We call it the Annexure E plan. We make reference to regulations, and we make reference to directions. Where COVID-19 compliance officer details are promptly affixed and communicated plus a designation letter. So when you appoint a COVID-19 officer, you do a formal appointment like you would do with any other appointment. So there needs to be a formal letter where the person is appointed. You need to make sure, like we're just revising your entrances and your exits. And how are you managing external parties, which is what we discussed. We also make reference to POPI because many people would say, but will we not be contravening POPI because we're giving NCID personal details? But obviously, this will comply with POPI because it's in the enforcement of a law. What we have learned is that you also need to have in your workplace, there needs to be the necessary notices about COVID-19 education, informing people about washing their hands, sanitizing, social distancing, and things like that. There must be masks, and hygiene needs to be of utmost importance. There must be identification of possible infection areas. So there needs to be rotation around places like kitchen, open plan spaces, basements, other areas where people may formally gather, in bathrooms. Protocol on immediate action if suspected on a confirmed case in the workplace. So that would be part of your Annexure E plan, where you would say that in the event that there's a suspected case, we immediately remove the person from other employees, put them in a secure, ventilated area, and provide them with a surgical mask, have them assessed clinically. Provisions on the employee who visit various places as part of their jobs. This would be for representative, for example. What would the protocol be for them to ensure that they have the necessary PPE, that they're wearing the mask, they have sanitizer, and there's a formal procedure in place in the event of them contracting the virus. Provision on traveling. This is communing. I know there was the regulated by the department as well in terms of how many people in a taxi and things like that, and then people have to wear masks in a taxi. There's protocol that needs to be on visitors. This is all part of your Annexure E plan. Communication protocols in cases of close contacts, vulnerable employees, special measures and reporting forms, which we've discussed, and the rights of employees to refuse to work. What this basically says that if the employer fails to have an Annexure E plan in place, or the employer has failed to do a risk assessment, or has failed to implement the preventative measures within the workplace, an employee will have the right to refuse to work. They will then have to report this to the Department of Employment and Labor, where an inspector would then come out to assess whether this has been done or not. And obviously this would then be a criminal offense, like we mentioned in terms of Section 38 of Occupational Health and Safety. So we need to also ensure in bigger establishment whether there is a health and safety committee, and you would then have to create a committee. This committee would be monitored and regulated by the COVID-19 officer, who would then also make sure that there's implementation. It is recommended that you take the steps and management in responses to those recommended steps. So in terms of the Annexure E plan, there must be people, designated people, such as the committee or the compliance officer, who physically make sure that this plan is implemented and monitored, that the protocols of screening are done on a daily basis, and the regulator in and out of the establishment. If it's a different entity after what is just hold on. Okay, and then you need to keep records and proof. So your screening protocols, for example, all of that information from day one, when you've issued it, you need to keep those records, and that would be important when you're doing trace contacting as well, when you're tracing, in case someone has contracted the virus. So inspectors may also look and check for everything else. So inspectors, when they do come out, they might not just look at occupational health and safety. They will also look at things like basic conditions of employment. They would also look at things like employment equity. If you need to comply with employment equity, do you have an employment equity plan in place? and they normally would do a full labor inspection. So reporting, tracking, and tracing is just, you'll see that there's a contact line list. These are forms that have been developed by the Department of Health, and we've included all of these forms in your Annexure E, and this is just an example of disclosures authorized under the Regulation 8 of the Disaster Management Act. And yeah, so I just put an example there for you. This is the COVID-19 contact line list. So this is where you would complete a contact line list for every person under investigation for the COVID-19 disease. And this would also be the form that you would then use when you have to inform the necessary departments or report to the necessary departments regarding a person who has contracted the virus. So reporting, you have to tell your employees, keep records under Annexure E system and show to the inspector. I've highlighted that this is an incident, just like any other incident. It's a occupational health and safety incident, and it needs to be reported as such. So the patient's doctor would report the COVID-19 case to the NICD using the prescribed forms. The employer must undertake contact tracing, which we've discussed, and using the template. You report this to NCOV. Reporting to the Department of Employment and Labor must be done with all occupational illness resulting in absence of 14 days or more. And then you would use the popular form, the WC. And then if COVID-19 is occupationally acquired, it must be reported to, and the cost thereof can be claimed from the compensation fund using the Comp Easy system. Reports must also be made to provincial health authorities, and then you can contact us in case you need the list. But I have included some of these within the presentation. Oh, okay, so I'm done. Is there any questions?
Are there any questions? You can put up your hand or take yourself off mute. Yvonne, if I can maybe ask one from my side, in terms of field reps and the contact tracing, whose responsibility is it, the employers to inform the hospital or the persons that that employee would have come in contact with when performing their duties, or is it just inform the hospital and the hospital's duty to then do the contact tracing within their own establishment?
So it goes both ways. The duty would be on the employer and obviously the hospitals as well, because they're supposed to have their own protocol and screening and contact tracing in place as well. Because the rep would be regarded as one of those visitors like we discussed earlier on. So there needs to be protocol for visitors that come into the establishment, but it's also the duty of the employer to keep a record or track of where the reps, the hospitals that the reps could go to, where there could be a potential outbreak.
Thank you very much. Are there any other questions? I don't see anything in the chat.
Okay. I hope that's a good sign.
I think that's a very good sign. It probably means that your presentation was very clear.
Okay, thank you.
Okay,
well, you have contact details. If you need anything else from me, I'll avail that to you.
Perfect. So if there is no further questions, then I would suggest that we can close this meeting slightly early. I would just like to thank both of our speakers for taking the time to address our members. Talita and Yvonne, both your presentations were very valuable to our members, and we appreciate you taking that time just to give us some of the insights. And then also want to thank everyone who participated in this members forum, and we look forward to welcoming you at future SAMED events.
Thank you.
And
have a good weekend, everybody.
Thanks.